So by way of introduction, as I started out saying, my name is Jackie Harounian. I'm a partner in the law firm of Wisselman, Harounian Associates, and we're a family law firm. I'm going to knock wood. We're currently one of the largest matrimonial firms on Long Island, and we service the Long Island market as well as New York City, and we even go upstate into Westchester and some of the upstate counties. Almost all of our practice right now is virtual, which makes it even easier for us to assist clients. And a lot of the work we do is really geared towards resolving conflicts by mediation, by working out agreements for custody, financial agreements, prenups and postnups. And really, we regard ourselves as trying to help people successfully resolve their issues and move forward. And that is so important when it comes to co-parenting, and no more so than with a special needs child. For so many reasons, when you have a child that's Luna's age, she's 4 years old in our fact pattern. She has a recent diagnosis on the autism spectrum, and she's entering the public school system. If parents are not on the same page as these parents are in our fact pattern, there's going to be fighting. If you layer that with infidelity, because in our fact pattern, Kate, who is the breadwinner, is earning a lot more than her husband, and her husband is not really necessarily pulling his weight financially. And I'm going to talk about that in my presentation, how that affects their child, who hopefully they will get on the same page and make decisions together. What happens if they can't do that? And all of the financial implications, because there are many new statutes and laws regarding family law, and a lot of it is very surprising, especially to women who think that things are going to unfold a certain way, and they're very surprised to learn that gender-neutral laws don't necessarily meet their expectations. All right, so here we are. I'm now going to start presenting on some of the family law topics that arise in a first consultation with a client. If Kate and John Brown were to come to me as a mediator, I would attempt to help them resolve some of their issues in a neutral fashion. And that's what mediation is. I'm someone who's helping two people try to find a middle ground on the issues that are facing them. And their marriage is deteriorating, their communication is deteriorating, and sometimes it's a very emotional point. And not every couple can work with a mediator for that reason, even when it's done virtually. But I do encourage people, especially ones that have simple cases, to consider going the route of mediation if they think it's the right process. It's certainly a friendlier and less expensive process. But if either of the parties were to come to me for a first consultation, either Kate or John Brown, and they were to tell me about the facts about their case, there were certain things that would really stick out from me, and I would take in my notes. And a lot of it has to do with the fact that they have a child that has special needs and who's in a public school setting. And there are issues concerning their daughter's medical situation, perhaps the need for medication, the issues of vaccines, educational decision-making having to do with IEPs, and working together with the resources in the school system and outside the school system, and also a lot of financial issues. I would want to know whether the parties are still living together, whether they're planning to live in the same school district, and what type of schedule is really in the best interest of the child. And all of this that's happening in this family is happening at a time where emotions are sometimes very high. Don't forget, Kate was recently accused of having an emotional affair, infidelity. Not everyone agrees that an emotional affair is infidelity. She might be denying it. And at the same time, we're finding out that John is collecting unemployment. He's a musician, but for whatever reason is not really working right now. So perhaps he's home with the child a little bit more. Perhaps Kate is the one going back and forth to work, paying all the bills. You can imagine it creates a little bit of tension and even anger in a family. And at the same time, we're hearing that some of the assets that are set aside for Luna are funded by John's parents. So every case is unique. Every family's fact pattern, the reasons that they're in conflict is unique. And so from a family law perspective, it's extremely important to take in the information and really come up with a strategy that's customized for that family and is hopefully going to get them, like I said, to sort of find a middle ground and agree on things. So before I go back into the fact pattern, I want to go through a brief overview of family law. I call it family law in the modern era. And the reason why I call it that is because the modern era really encompasses the past 10 years, where there have been very, very dramatic changes in family law that definitely impact families such as the one in our fact pattern, and more importantly, affect the client's expectations about the process. It affects their reactions to the process, whether they think the system is fair or unfair, whether they're stressed by it. And don't forget, we're in the middle of a pandemic, so divorce already is a stressful process, and obviously it gets so much more stressful when we're talking about issues related to the pandemic, financial reversals, remote learning, school issues. And so let me go through some of these changes in the law, and then we'll get back to how that might affect our family. First of all, when I do an intake with a client, if I know that there is some issue regarding special needs or estate planning, I will absolutely bring that up at a first consultation, because going through a major life transition, such as a separation or divorce, is the best time to meet with a special counsel and with a financial planner to make sure that those issues are also being addressed. So I know that Babita will cover those issues in her presentation, going through any life transition, including a divorce, including the death of a spouse. These are times where you need to really consult with experts and make sure that you are really paying attention to other types of legal issues and also financial planning issues. And we're going to hear a lot about that from Babita right after I'm done with my presentation. So the first topic in the overview of family law is no fault grounds. So no fault grounds means that virtually every single case that goes through the New York legal system in divorce matters is no fault. No fault means that it's basically irreconcilable differences. The parties allege that the marriage is irretrievably broken. Actually, the plaintiff can allege it, and the defendant doesn't have to even agree to it. It can be like a no contest. So no longer do you have to prove grounds that are very negative, including adultery, including cruel treatment or abandonment or constructive abandonment. 10 years ago, before these grounds were changed, those other grounds are still available, by the way. It's just that now no fault grounds are now the preferred grounds that most lawyers and judges emphasize and encourage. We are now starting almost every single divorce case where it simply does not matter what went on before the client came into the lawyer's office. I'm not talking about domestic violence. Domestic violence or certain mental illness issues may impact the custody issue, but domestic violence, in most cases, marital fault, adultery, abandonment, really do not affect how the money, how the assets, how the support is determined. Again, there are exceptions to every rule. And the information I'm giving out now, I'm really giving out in a general way. But going back to our fact pattern, whether or not Kate was having an emotional affair or an actual affair, or maybe a dozen affairs, really does not impact the custody issue or the financial disposition of the case. And that's very shocking to some people. It is certainly upsetting to many people that think that it's such a big issue. And a lot of it has to do with the blaming and the negativity that really starts out most divorce matters. I encourage most of my clients to really try to address those types of issues, those feelings of betrayal and anger, with mental health professionals, in marriage counseling, preferably, or in individual counseling. It is so important to sort of compartmentalize the feelings that parties have against each other as ex-spouses versus their roles that are now shifting into co-parenting roles. So Kate and John are no longer an aggrieved spouse upset at another spouse. They are now former spouses that are potentially still living together as reluctant roommates, but they're transitioning into a role of co-parents that have to raise their child together and have to financially support their child and protect their child. So this is a very, very important change in perspective. I know that there's a lot of mental health professionals that are listening right now. I know that a lot of you, when you're treating your patients at the beginning of marital breakup and the beginning of custody situations, that's exactly what you're dealing with, how to overcome the anger and resentment that starts out a relationship breakup. Again, by the time they come into my office, I'm really explaining to them that the grounds for divorce are no longer relevant to really litigate. And sometimes it does take one or two consultations before that really sinks in. And in general, most clients, I would say 80%, within a few weeks and months into the case, they're ready to shake off those feelings of anger and move forward to the other issues in the case. So the no fault grounds is really a general rule at this point. You're not going to find many cases with other grounds. The next item is gender neutral laws of custody and support. And when Karen and Babita and I came up with this fact pattern for today, we very deliberately came up with a breadwinner spouse who was the wife, and the stay-at-home spouse, maybe the primary caretaker, who was the husband. And this is something I'm seeing more and more in my practice today. Probably a third of the cases that come to my office, and we have a very high volume practice. We have 9 attorneys here. Probably a third of the cases, the wife is earning more or the same as her spouse. And this is very different from what I would see, when I started practicing over 20 years ago. So gender neutral custody and support laws mean that there is no longer a presumption in favor of the mom or in favor of the dad. It's both parents are starting out with a joint custody paradigm. They're starting out with equal rights and equal opportunities to pursue custody, even 50-50 custody, which was almost unheard of 10 years ago. Very much a small minority of cases that had 50-50 custody. And now we are seeing more and more parents that are very interested in 50-50 custody, especially now during the pandemic. Lots of parents are working from home, teaching their children from home, remote learning. And so it's also this word of mouth that's happening. A lot of fathers are finding out that their friends are getting joint custody and are having several overnights per week with their children. And it's very important to understand, especially for the moms that are very invested in this idea of being primary caretakers. And a lot of them were the primary caretakers prior to the separation. A lot of them were doing the lion's share of the homework and the bathing and the feeding, and the father maybe wasn't as involved. Or obviously, gender roles could go the other way. What's important to understand, especially again when I'm talking about setting expectations, is that the law is gender neutral, and both parents do have a shot at joint custody. And mothers do pay child support, and fathers do receive spousal support. Again, this is becoming more and more the norm. Just flipping to the mom's perspective for a second, I have many, many CEO moms, doctors, professionals, very high earners, and I see that they are embracing the opportunities provided by joint custody, which gives them several nights per week with their children, and then several nights per week where the children is with the father. And for the higher earning moms, the ones that have very demanding careers, perhaps with travel, they are using those opportunities to advance their careers, to focus on their own hobbies and interests and social life. And more, I see moms that are accepting it and even like it. And the stigma for the moms that don't have primary custody is going down very rapidly. The stigma for the stay-at-home dads that proudly say, I'm home with my children and I'm raising my children, that stigma is going away, which is obviously a very positive thing and is very much a reality. Spousal support is still part of the law. It's still a very controversial part. It does lead to quite a bit of conflict. A lot of times parties do need help from their attorneys or sometimes a ruling from a judge, because no one wants to pay spousal support, whether it's the wife or the husband. It's very unpopular, but it's still provided for that the higher earning spouse, the moneyed spouse, sometimes does have to pay spousal support. What's new in the law is that spousal support is no longer tax deductible. So going back to our fact pattern, we can expect that if Kate is the one earning, let's say, 6 figures and is the primary earner, and we have John, they've been married for 6 years and they've filed joint tax returns, I'm going to take a guess and say that John probably was not reporting a lot of his income on the tax returns. He's a musician. I don't know how active or how much income there is, but I'm guessing some of it might not have been reported, might have been in cash, or maybe he just wasn't a high earner. So to me, that is something that is going to have to be addressed, the issue of spousal support and the problem that Kate might have if she challenges her own tax returns. If she filed joint tax returns with her husband, it's not going to be so easy for her to say, you know what, he really was earning some money off the books and we just didn't report it, but now I want him to have to admit to it. It's not very easy to do that. Businesses and degrees are also an issue that's changed in the law. Degrees, medical degrees, law degrees, real estate licenses, these are no longer marital property. That's another change in the law that's relatively recent. It might impact a lot of people that expect to get a piece of their spouse's medical degree or license or fellowship. That's no longer the law. I can't go into that now because it's actually a very complex and significant issue. The final issue on this list of overview is counsel fees. The moneyed spouse does still have to pay counsel fees. Counsel fees are a very, very significant part of family law and divorce matters, should really be an issue of concern for everyone because someone has to pay the lawyers. And this goes back to what I started out saying, that every couple, every individual has the opportunity to choose less expensive, lower conflict processes, including mediation and out-of-court settlements. So even if you can't use mediation as a process, there's no reason why you can't work with an attorney and try to make concessions and compromises when it comes to the issue of custody, especially, and with finances and support issues too. There are some issues that cannot be resolved that easily out of court. Obviously, the issues of domestic violence, orders of protection. If you have parties that are hiding assets or are not paying the mortgage, or there are emergencies that come up financially, a lot of times we're dealing with people with personality disorders or mental illness. They are just not going to do the right thing. They're not going to be reasonable. There are dangers sometimes that exist for small children. If there's a parent that is mentally ill or using substances, there's a time and place to go to court. And certainly if that's necessary, that's what you have to do. And that does have a cost factor. We do offer in our firm a free consultation. Consultations are very important. We usually encourage clients to meet with several attorneys before they hire one. You can get a lot of information at a free consultation, including referrals to family court or ways to maybe streamline your case or have more cost-effective strategies. It's really important that you get legal advice that's tailored to your exact situation so you don't make a mistake. Karen, can you move to the next slide? So these are just some of the coronavirus specific issues that we have seen in our office that are escalating. Domestic violence for sure, substance abuse and child neglect. These are all on the rise. There's a lot of crimes being committed behind closed doors, a lot of children that aren't attending school, child neglect, educational neglect, and substance abuse. A lot of people and teenagers are using substances to cope with the stress, the uncertainty of what's going on with coronavirus and everything else that's going on. I think we can all acknowledge there's just a heightened level of stress. We are seeing in our office a lot more questions, and we're having a lot more consultations regarding modifications of custody and relocation. We have several cases right now where parties are moving out of the county or out of the state, relocating without even telling their spouse that they're estranged from, or violating court orders and agreements. these are issues that have to be dealt with very proactively, because if you wait too long to contest a modification or a relocation, it could be a problem. But there are definitely a lot of relocations going on. A lot of also child support modifications because people are experiencing changes in their business revenue or they've lost their jobs. A lot of people are fighting over the stimulus checks and tax issues. So these are very specific to this period of time. And this is what we're seeing in our office. Karen, the next slide, please. Okay, so now I'm going to talk for a few minutes about special needs issues relating mostly to school and medical issues. And I'm going to try to tie it into our fact pattern. So one of the issues of major conflict with parents has to do with education. It has to do with educational decision-making, and a lot of that actually overlaps with medical decision-making. And you have parents such as Kate and John that sometimes are on the same page. They're raising their children. Maybe there's an issue that emerges with one of their children that's been brought to their attention by the pediatrician or that they've observed together. And because of the unique aspects of their relationship or their child, they fall into a pattern where they agree on most issues. They trust the advice of their pediatrician. They're on the same page when it comes to, applying for services or trying out different medications or trying different treatments. They are working together in a way that's synergistic, and for whatever reason, it just works. A lot of times I see that it's a lot is the one who's home more with the or more of an interest issues. But I have also happened the father is more of the decision maker. And I've certainly seen cases where the parties are arguing about lots of other issues related to the marriage, but when it comes to children, they agree. So that's wonderful, and that should be encouraged. You always want to have parents that agree when it comes to their child's education and medical issues. And to some degree, this issue is the same when it comes to parents that have a certain religious background or have certain traditional background, where it's very important for their children to go have a certain type of education, whether it's a yeshiva education or a kosher household or eating in certain restaurants. We have parents that agree on those things, and even when they separate, can replicate those rules in both households and work harmoniously with education and medical issues. And then we have parents that sometimes are drifting apart when it comes to values, traditions, religion, culture, and that becomes a breaking point in the marriage. And then we see it play out with the children. And that's very unfortunate because it's very hard to resolve those types of issues. So when it comes to special needs children, if the parents do not agree about the child's diagnosis, let's assume in our fact pattern, Kate, the mom, does not think there's anything wrong with Luna. She doesn't believe her child is autistic. She doesn't think her child needs special services. Whereas the father, John, believes that there's an issue, wants to take the lead in maybe pursuing some of these treatments, getting expert advice from doctors or specialists, maybe have the child put in a special program that perhaps doesn't exist in their school district. Now, if Kate and John are going to clash over this issue, they're either going to have to go to a mediator and resolve it. They might be receptive to listening to Luna's teachers or pediatrician, and sometimes parents will agree to defer to the expert advice of the pediatrician or the child's teacher. If they're not going to agree, they're going to end up in front of an attorney, and they're going to be arguing over who should be what's called the primary decision maker. And what I have here on this slide are some of the issues that go into school choice and why one school or one program might be preferable to the other. I have a number of cases right now where educational decision-making is a factor, and where the parents start out with joint custody, and every married parent has joint custody before there's a court order that takes away their custody rights or gives them more custody rights. As I mentioned, in the vast majority of cases, there's a preference for joint custody, and there's a preference for what's called joint legal custody. And that means that even if the child is not living 50-50 in both households, the parents have more or less 50-50 rights when it comes to decision making. And that means that neither party has a greater right than the other to choose the program or direct, the conversation with the doctors and the teachers, or take more of a vocal stance when it comes to the IEP or school meetings. The parents have equal rights. And again, where they agree, that's wonderful. Where they don't agree, it can be disaster. So as teachers know and doctors know, if the parents don't agree, they need a court order or an agreement so they know what decisions can be made. Um, I have a case in my office right now, which is actually very similar to the fact pattern. I have a family that's relocating from the city to Long Island, and the parents are not on the same page about the relocation. The mother has found a school district with a wonderful special services department and reading resources for their child, who she believes needs that extra help. The father refuses to agree. And so, unfortunately, we have to go to a judge and get a ruling. And the ruling we're asking for is to give our client what's called primary decision-making authority. We want her to be able to choose the school, choose the program, and make decisions on behalf of the child when it comes to the child's education. And in this way, she'll be able to make decisions regarding the programs, regarding the teachers, regarding class size, regarding services. And without getting that ruling from a court, this child cannot get those services. We have very similar situations when it comes to vaccine refusal. We've had cases litigated where one parent believes in the vaccine, the other one doesn't. The public school requires the vaccine. I'm referring to the polio vaccine and the basic immunizations that public schools require. And you need a ruling from a judge. Is this child going to be vaccinated and be able to go to public school? Or is this child not going to be vaccinated, in which case the child has to be homeschooled, or there has to be a private school that will accept the child? So these are the types of conflicts that come up in family law when it comes to school choice and decision making. And as you can see, it's very, very important for parents to communicate before the marriage breaks apart, to maybe agree to defer to the pediatrician, or maybe both agree to get second opinions, or talk to teachers or specialists or special education attorneys. And if anyone needs referrals, my office can give referrals for these types of situations. Finding a middle ground on custody decisions is exceedingly important. Otherwise, you're really leaving it up to a judge to make a ruling that may or may not be agreed to by the parties.